Now you can.
All right.
Slayer.
Okay, we're back for the last session we have today, which is about process and procedure. And we're really fortunate to have Ryan Call and Peg Pearl with us. And Ryan was formerly the chair of the Republican Party in Colorado, and so he's very familiar with these processes. And he is frequently practices in front of the administrative law judges in the Colorado courts in areas of campaign finance and election law. And Peg Pearl is the senior counsel for Colorado Ethics Watch. And before starting with Ethics Watch in 2012, she practiced for a decade in Washington, D.C., including public service positions as counsel to the U.S. House of Representatives Ethics Committee and an attorney with the Federal Elections Commission. So she's practiced in this area in Colorado frequently. Ethics Watch is commonly a litigant or an amicus brief on campaign finance issues in Colorado. So I think we will be getting a lot of good information out of them.
Can everybody hear me if I work on this mic, and then we've got that for that, so that's fantastic. Well, it's great to be with you guys, and we understand that this is being taped, so that there are going to be quite a number of other folks. So our presentation is going to be oriented both towards kind of an overview of the way the complaint process works, with an eye towards many of you who are either administrative judges or working in the courts, Secretary of State staff, but then we also have an understanding that there may be practitioners who, and this is not an uncommon situation where a candidate who's running for a local office, a local measure, looks to someone, a member of the bar, as a volunteer because they're an attorney, and well, can you help me respond to this campaign finance complaint? Or I want to bring a complaint, how do I do that? So we're going to kind of gauge our presentation and kind of talk about the way the process works, a few different sort of paths and how this kind of unfolds, and then address some maybe suggestions and observations about how to make the process a little bit less painful for everybody involved to the extent that we can. So Colorado Constitution, Article 28, Amendment 27, Section 9(2)A is really what governs this process, and I apologize for the somewhat small text, but it's a long and lengthy section. It talks about how that it defines that private right of action, at least until federal courts decide that it's unconstitutional to have this, and is chilling on political speech. This is the system we have in place, and that any person can bring an allegation and file a complaint with the Colorado Secretary of State's office to alleging that violations of not only the constitutional provisions but other provisions of Colorado's campaign finance regime have been violated by any actor. Then the process is a very quick one. And many administrative courts judges have commented to me how pressure it is because of the turnaround time. Within 3 days of having received that complaint, the Secretary of State's office refers it over to the administrative court, and notification of the party who is being complained against, the respondent, is given, and a hearing is set within 15 days. It is a very quick process, and we're going to talk a little about the way that process sort of rolls through. Once the decision of the administrative law judge, it is final, but it is subject to review by the Court of Appeals. So rather than appealing to district court, it's a direct appeal under 24-4-106-11 to the appellate court, and then Supreme Court beyond that if necessary. And it's interesting that the constitutional provision says specifically that the Secretary of State and the administrative law judge are not necessary parties to the review. We will talk about intervention by the Secretary of State's office, which is becoming increasingly more common, and some good reasons behind that, as well as some observations about the process by which that process kind of unfolds. And then the enforcement of the judgment by the administrative law judge goes back to the Secretary of State. So even though under the Constitution and the kind of plenary authority of the statutes, the Secretary of State was tasked with enforcing campaign finance law, it's kind of a handoff to the ALJs to do this case, and then it comes back to the Secretary of State's office for the enforcement of those fines and penalties pursuant to the ALJ decision. And then we're not going to delve too much into this question about a private cause of action, just because those are pretty infrequent, but you may want to talk about that a little bit if you like.
Sure. So I think this is on. The way that the enforcement structure is set up is that it goes back to the Secretary of State's office for enforcement, but there is the option for whoever the individual or organization is who filed the original complaint to then also If more than 30 days has passed, the Secretary of State has an enforcement of the judgment to file sort of a private enforcement right of action and move that through. Again, as I think was mentioned in the first presentation today by Scott Gessler, it's not that you're moving to enforce the judgment of those fines so that it can go to your own coffers, so the person filing the complaint isn't trying to recover those fees instead of the state. It's just to get that payment to be made to the state as proper. But there is a provision for then being able to have your attorney's fees for doing that enforcement action. And we'll kind of talk about that when we get towards attorney's fees more detailed.
Great. So let's talk about the way this process sort of starts out. And Peg, you want to tackle this? So in your packet of materials that we provided, that's how that process starts. And that's this cover sheet. And then we're going to kind of provide a couple of illustrative examples of the way the complaint process kind of unfolds.
Sure, and I'll kick this off, and Ryan will chat about this too, because I'm kind of the representative up here, at least on this panel, and I think even more often in the other panel, of someone who's on the filing side more often, well, all the time, pretty much. My nonprofit doesn't get sued in ALJs, although we do occasionally get sued in the federal courts, which we can talk about later, but filing the complaints. And so there's a cover sheet that's sort of at the top of this packet here, and basically the important thing about this private enforcement scheme that we've talked about is not only the timeframes, but the access for information, right? And so whoever files this complaint, one of the things the cover sheet does is make sure that everybody knows when you're filing a complaint, you're actually signing up to prosecute this thing. You want to make sure that folks aren't filing something with the Secretary of State's office and then now thinking, oh, the Attorney General's office is going to run with this, or the Secretary of State's office is going to run with this. So that's why there's language on here for the complainant to make sure they know, hey, you're the one who has to be able to have whatever evidence you have or go in and actually prove this, show up at the hearing and go through the process. So that's an important part of why this complaint kind of cover sheet exists by the Secretary of State's office.
And just an observation for practitioners, this is a necessary element. If you just sort of send an email to the Secretary of State's office saying, hey, they're doing something bad, look into it, Secretary of State's office is going to be like, you know, do you want to file a complaint? If so, here's the cover sheet, you got to file it properly. And there's been a couple of examples even recently where someone has written a letter and then the Secretary of State's office rejects it. And then they file it again and they reject it and they say, okay, finally they turn it in with the proper cover sheet and the acknowledgement that the person who's signing up to prosecute this complaint understands that they're making some allegations that not only they have the burden of proof, but they also could potentially be on the hook for legal fees if it's found to be a groundless or frivolous complaint. And then the process then moves over. The Secretary of State's office does not have, as much as we might like them to sometimes, have any real authority, unless you're going to dispute it, to kind of head it off at the pass. If it comes in properly and everything's in order, they refer it directly over to the administrative law judge. They don't really have the authority to dismiss the case or kick it out for failure to state a claim at that level.
Right, so this is really clear, and to be honest, because of the way that this is set up, you could have the actual complaint look totally different depending on who files it. The cover sheet will look the same, which is required by the Secretary of State's office, but moving on to sort of the second bullet point here about parties, what the Constitution says is that any person can file one of these complaints. And so you can have just a citizen who files something, they're not an attorney, they don't have an attorney on retainer, they can do it themselves. And so you have a cover sheet, but then behind the cover sheet, the complaint itself might really be a very informal letter type of writing explaining what they think has happened and what violations have occurred. Or you could have a situation where it is filed by an organization that has attorneys. So I basically represent my organization. We don't take on private clients. And our complaints that are attached to this cover sheet look very much more like a court pleading. And so the requirements are not firmly imposed in terms of like pleading standards on what goes behind this complaint, because the Constitution does say any person can go forward with it, and specifically through the Constitution and the rules of the Office of Administrative Courts, individuals can be prosecuting these cases themselves without attorneys.
I've even seen examples where there is nothing that goes behind the cover sheet, that the claims that are laid out are simply typed up or even handwritten in this little box on the cover sheet, and that constitutes their complaint, and that's sufficient to essentially overcome these kinds of things. We've provided a couple of examples. We thought it would probably be most helpful as we kind of walk through a couple of examples of complaints. One, and with permission of Mr. Ramey, is an example of this kind of informal letter style complaint directed to the Secretary of State with exhibits that are attached, and then the way we'll kind of talk through the way the case kind of proceeds. And that is on page 3 of the handouts and materials. And another example of a complaint in the way it would be filed with the Secretary of State's office and then prosecuted would be beginning on page 35. And this is a complaint that was filed recently by John Andrews, represented by the law firm with Scott Gessler and Steve Linda. You can see that there's some differences with respect to the approach that's taken in the layout of the format of the claims. But in any case, it's perfectly fine. That's probably the reason why we provide these as a couple of illustrated examples. But you can see on that cover sheet, we're taking a look specifically on page 3, the one filed by the complainant, Elizabeth Ann Geiselman, her mailing address, phone number, email address, the attorney representing Mrs. Geiselman and the law firm, contact information, and clearly identifying who is the respondent, who's the candidate and candidate committee here, kind of identified jointly, and then the summary of information, and then it's under signature of both the lawyer and the complainant, although the complainant's signature is the only one that is required. As you can see, better complaints, and from advice to practitioners in this arena, the more detailed you can make your allegations, the more exhibits you can attach in your initial complaint so that folks have an understanding of what's all there, the easier it is to sort of address the issues, specifically as citing to the particular provisions of the Colorado Constitution, the state statutes, identifying how the complaint has been done. And this question about groundless or frivolous is important because it is, in my opinion at least, not sufficient to just simply make these wild allegations without any basis in fact. You're putting yourself at risk as an attorney in terms of a violation of the rules that govern attorneys filing complaints, but even a private individual will put themselves at significant risk in getting hit with legal fees and attorney's fees by filing a groundless complaint. And so the complaint process really does shift the burden of proof on the person making this complaint. It is not an invitation to go on a fishing expedition to see if there was a violation. You've got to be able to have a good faith evidence in hand to be able to show that there was in fact a violation, because the burden of proof is on.
And I think there's an important practice point here to keep in mind too with the timelines that have been alluded to. So one of the things that's important to keep in mind, there's a very short statute of limitations. You have 180 days basically after the date of the alleged violation to file these cases. So these two things are in tension, right? What Brian was just saying about how get all these facts and these documents and get as much as you can together about what the violation is, but do it all in 180 days or less, because if it's 108 days from the violation, but because of the reporting schedule, you don't actually find out about it until 30 or 60 days later, and then you're trying to piece things back, and you figure out when your statute of limitations runs. If it runs from the reporting date, fine, but it's still a very small period of time. And to keep in mind, even if you're an organization as opposed to a citizen, this is something that you're putting together without government investigative subpoena powers or something like that. So you're really canvassing the public record. I can say the majority of cases, a lot of times that we work on as organizations, Tracer obviously is a huge trove of information, right? You'd be looking at all those reports, looking for things that are either missing. There was a good example earlier about how, oh, I got this mailer at my house, and I look up the name of the person who sent me the mailer, they're not in Tracer. Okay, that's where you kind of start down the road of gathering information, but at the same time, there's a short period of time to do that. And so I think that it's important when we're applying these standards about frivolous complaints or about without substantial justification, especially when it is a system where it's left to private enforcement without government investigative powers, that there has to be some recognition of the limits to how much information you can get together. I certainly don't think it should be completely, 2 sentences of allegations and you're done. But on the other hand, sometimes you can't have every little piece of evidence, and we'll walk through and talk about how along the way You can get little bits of discovery to sort of bolster what you're putting together. And I agree it shouldn't be a 100% fishing expedition, but I think, just the fact that you don't have every piece in place by the day you file the complaint is not the standard that necessarily people are being held to. But there is this standard, and I just want to say that does address some of the concerns that were raised earlier today about political enemies just filing quickie complaints just to get a news hit or something. There is some sort of penalty for doing that. If you really just have groundless, I'm trying to get a quickie hit on the news cycle about someone getting a campaign finance complaint filed against them, there's really no substance to it. There is this provision here about, frivolous complaints or things where you could be on the hook for attorney's fees. So, and especially when you are talking about folks who are members of the bar, we have our ethical violations, our Rule 11, sort of obligations. We take it very seriously, our threshold for what we file. And that's just because of all of those obligations wrapped up together before we file something and take the obligation to have to prove something very seriously. And so you got to try to do that quickly.
I'll also make the observation just from the perspective of timing. While in the overwhelming majority of cases, the respondent will typically enter an appearance or even the individual respondent individually and immediately ask for a 30-day extension on the hearing, they don't have to. If you don't have anything and they know you don't have anything, they could go to the hearing in 15 days. And if you don't have your case pulled together or your facts ready to present, you don't have any time to do any additional discovery or witness within those provisions or within the provisions without really putting the squeeze on the rules of procedure in terms of subpoenas and responsiveness and documentation. So if you don't have your facts and your factual record, or at least your arguments ready to go, you may find yourself in a situation where you've made these allegations thinking that you're going to get a month or two of additional discovery, and in fact, you might not. They might just say, let's go to trial, let's go to hearing. And then you have to show up as either the complainant or the representative of the complainant and be ready to put on your case in chief in 15 days.
Yeah, you definitely have to be prepared for that, for the 15 days to be your window.
So let's talk through just a couple of illustrative examples of the way this process kind of comes through. Again, recommendations with respect to the claims is that you lay out the factual record as you have it, you provide exhibits or attachments, you identify specifically what are the violations of the law, how they're violations of the law, and then outline, to the extent that you want to, what the requested penalty, what you're asking the ALJ to order. In some cases, it's a directive order. The complainant is ordered to file amendments to properly disclose the information, or the entity responding is ordered to register as a committee and then file proper disclosures. Or what is the calculation of the fines and the penalties that you as the complainant or the representative of the complainant are asking the ALJ to be able to lay out. While there is a bit of a question as to whether the administrative courts are obligated to file the guidelines of the Secretary of State in connection with the imposition of fines and penalties, it's always, in my opinion, helpful to at least point to that as a recommendation to the courts. And that's what we'll kind of talk through in this. Let's take a look at this first example. You can see in the complaint in the form of a letter directed to the Secretary of State filed by Mr. Ramey back in 2014, beginning on page 4.